I have a question. Is your site up because some of us can't get your site up?
Yeah, I emailed them when the semester began. I reminded them that they blacklist certain sites and make sure mine wasn't on it. The response I got back was, oh, if you've been removed from the blacklist, that's removed for good. So I'm sorry if they misled us on that.
It's not loading right now, so we just can't follow the sign in.
Yeah, that stinks.
So do we need to do anything or?
Well, yeah, I gotta sign in, so I'm sorry that we can't do it from here.
So what do you want us to do?
Sign in from somewhere else.
How, if the site's not working?
Oh, well, the internet as a whole is working, but this Wi-Fi here on campus has a list of websites you're not allowed to visit. Mine was on it, but I asked them, please take me off it. And they said, okay, we agree, you're off it. Now you can visit on the campus. And then as the semester began, I emailed them again. I said, hey, don't forget, you need to keep me on the list of websites students and visitors of the Barry Ball campus are allowed to visit. And they responded with, oh, yes, of course, if you were ever removed from the blacklist, then you are forever removed from the
We
blacklist.
signed in fine the last 4 weeks.
Yeah, I know. So I wish it were true that I remained off the blacklist forever. I'll remind tech support that I don't think I should be on the blacklist.
So we're fine signing in tonight or tomorrow?
Sure, yeah. Yeah. Hello.
I think your site actually may be down. This is cellular data and I can't access it.
Oh,
Yeah, so just let your tech people know.
okay. Yeah, so that's not the Wi-Fi.
This is cellular data. Yeah.
Yeah, okay. Well, that goes after me, man. Well, that you set me straight. But the good news is I don't have to worry about being blacklisted by the campus, so that's good.
If you are, let me know. I'll email you too.
Okay, thank you so much. Hello.
Question, Professor.
Yes.
So I know our midterm is coming up in the next few weeks.
It is.
And I was
It's
wondering,
true.
where could I find like some questions that to practice for? Like, do you have specific questions you'd like us to use, or any source that I can find that like
So you're looking for,
practice questions, like for multiple choice or essays?
well, on the class website, which apparently is either down or blocked at this moment in time, but hopefully we'll be back shortly. On there, there's a past midterm. That's a
Oh, yeah?
good place to look.
Oh, okay. Awesome.
Yeah.
I'll check that out. Thank you.
Yeah, I'm trying to remember. It was when you log on, there's the ribbon of buttons.
Right.
I pull up the site and point to it. If I could pull it up, but I can't. And the first button is fall 2021. I think it's 2 buttons later.
Okay.
And you
I'll go through
scroll
all of them
down.
and try to find it there.
Yeah, there's a on the screen where you click on it. There's a picture of like a man's business suit on a coat hanger.
Yeah.
Yeah, it was free clip art. So,
Okay.
what does a man's coat and business suit on a hanger have to do with the midterm? I don't know, but it was clip art. It was better
Dress
than
code,
nothing.
I guess.
I guess.
So for the midterm, do you know if it's going to be just multiple choice or also essay questions?
All multiple choice.
All multiple choice? Okay, awesome. Thank you.
Yes. Mindful the website may be down. If so, please be sure to sign attendance later. Hey, that's good news. I like websites that work. All right. Welcome back, everybody. You can't make a law like that. That's been our topic. And that topic continues with today's lecture. You can't make a law like that. You've got to follow proper procedures. You've got to do what the Constitution requires you to do. Lawmaking has its limits, and that is what we have been exploring in our last lecture, and this is part 2. We continue that exploration today. I am giving you the tools you need as an attorney and a litigator to prove that there has been a violation, which allows a court to say, you can't make a law like that, and therefore renders that law unconstitutional on its face. These are the weapons you may use to fight improper lawmaking, just as an archer has arrows and she or he will keep those arrows in a quiver on their back. These weapons are the arrows in your quiver in the fight toward proving improper lawmaking. With that said, I always begin every class with a prayer. Thank you for allowing me to do that. As always, I'm not praying at you. I am praying for you. I'm praying for your success in this class. I am praying for your success as an attorney fighting for your clients. And I am praying for your success in life. And as always, I pray in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Lord God, Heavenly King, Almighty God and Father, gathered here today are your lawyers. They are your warriors for justice here on this earth. No earthly system of justice can ever be perfect. But yet, these lawyers strive for perfection. Guide their hands, guide their minds, aid them as they fight for justice, and aid them as they do your will Let your will be done. Amen. In the name of the Father, and Son, Holy Spirit. Amen. Where did we leave off last week? No, I tried these batteries just seconds ago. Oh, man. It's happened to me once before, remember? And I lamented that I'm supposed to bring my own slides. I didn't know I was supposed to bring my own batteries. Well, now that I know, I do indeed have my own batteries with me. Bear with me for just a minute. Like, get them out of my bag. Who knew I'd need them? Who knew? All right, let's see. All right, I got all different shapes and sizes here. Not sure what shape and size. Oh, these look like AAA dead batteries. Where's that recycle bin? Do we have the appropriate recycle bin for dead batteries? Is it labeled for paper? I'm gonna keep them in my pocket just till I find out. Okay. All right. Let's see. Any AAA, AAA, AAA. You know, like your report card, right? Bunch of A's. Yeah. All right. Okay. New batteries going in. Okay. Fingers crossed. Let the slide advance. Come on, man. Seriously? No. Huh. Maybe it wasn't the batteries? I don't know what to tell you. There we go. I don't know what it was. But whatever it was, it's fixed. Likewise, let's hope the website is fixed. I heard it might have been down at one point. If so, be sure to sign the attendance sheet when the website is up. Make sense? All right. So let's get back to our story, shall we? What were we doing? Oh, we're looking at the limits of lawmaking. You can't make a law like that. Where did we leave off? The last arrow in your quiver that we discussed talked about amending existing laws. Now let's put another arrow in your quiver, shall we? Let's talk about title requirements. And before we talk about title requirements, let's compare and contrast the two uses of title. What do I mean in this particular lecture when I talk about title requirements? Well, when we talk about laws, some laws have a name, if you will, which either lawyers or non-lawyers might refer to as a title. For example, Chapter 120 is the Florida Administrative Procedures Act, or the APA. Administrative Procedures Act is one way you can refer to it. And some lawyers might call that the title. Likewise, Chapter 440 of the Florida statutes is the Florida Workers' Compensation Act. And it says there in 440.01 that it may be referred to as the workers' compensation law. So when we refer to it as the workers' compensation law, you might say, well, that's its title. With all those truths being recognized, that's not the kind of title we're talking about here when we talk about title requirements. What are we talking about here? We're talking about that long paragraph we referenced in our last lecture that the bill was given as it moved through committee and the two bicameral houses of the state legislature on its way to becoming a law. You remember, we talked about that title when we talked about the single subject rule. We talked about that title as a lengthy paragraph, a bunch of semicolons. When it comes to the grammar, when it comes to the language arts, it might be an awkward sentence. It might even be technically, from a language arts standpoint, a run-on sentence. But nevertheless, that's the title we're talking about. If you've studied from my text, you saw how a bill becomes a law in the Florida legislature, and a title is needed. That's the title we're talking about. What are the requirements for that title? What are those title requirements? First, the title is not part of the statute or the ordinance. Instead, it is separate. It is not a law in and of itself. You wouldn't march into court and quote from the title and allege that to be a binding law because you would be technically incorrect. However, the title is reflective of legislative intent. What did the legislature intend with the plain language of this particular law? One way we can argue what the legislative intent was, and one way that the courts can cite to legislative intent is by citation to that particular title. What are the requirements of the title? What must the title have or not have? Well, the contents of the title must be, forgive the double negative, not inconsistent And again, I realize that's a double negative, but from the case law, that is the legal standard. So I'll use the double negative here. The contents must be not inconsistent with the general subject of the title. You might avoid a single subject rule violation by putting seemingly unrelated topics within the same title. We talked about that in our last lecture. So don't think that the title is flawed because it has in its list or in its paragraph or in its words seemingly unrelated topics. Indeed, that is one of the tools in the legislative toolbox that may be used to avoid Florida's single subject rule. So that in and of itself is not a title requirement violation. The title is sufficient if topics are fairly related to it. What do I refer to here? The title and the topics of the law itself must be fairly related. If they are fairly related, then the title is not flawed. The purpose of the title ultimately is to give adequate notice of what this particular law entails. Remember where the title came from and what its use was in the lawmaking process. It was up on the big board where the lawmakers could see what was today's topic. It was on the printed agenda when the lawmaking committees got together. It was the means by which this bill traveled through Florida's legislature. Its purpose was to give adequate notice of what today's topic was, of what today's committee meeting was talking about, as to what these legislators were voting yes or no on. That was the purpose of this title. So if the title is fairly related to what appears within the law, then it has met the legal standard. If the contents are not inconsistent with the general subject of the title, then the legal standard has been met. What's the flip side of that? As you, the litigator, trying to strike down a law, how is this an arrow in your quiver that you might use to prove you can't make a law like that? Well, you argue, perhaps successfully, that these legal standards are not met. Perhaps within that law is a topic that is not fairly related to anything one might find within the title. Therefore, the title would be inconsistent with the general subject of the law, and therefore you would have a successful claim that this law is unconstitutional on its face under Florida's Constitution. Make sense? So we put that on the big board, and also on the big board, we add another arrow to your quiver. Now let's talk about zoning laws. Zoning laws under Florida's Constitution have particularized requirements, and in those requirements you can find yet another arrow in your quiver. We must understand, however, the difference between a law that is a zoning law and a law that has to do with behavior upon land. Ordinances that pertain to a specific activity rather than the use of the property are regulations, not zoning ordinances. If it's a regulation, not a zoning ordinance, then it's subject to less stringent notice requirements than you find for zoning laws. McGinley, help me understand that. Okay, I will. If the law you're looking at talks about the particular zoning code that's applicable to that plot of land, or what category on the zoning map that particular plot of land applies to, you may be confident that you are looking at a zoning law that is subject to the strict requirements I'm about to go over, and therefore might fall to an arrow in your quiver. However, if that law simply talks about how one is allowed to behave or not behave while present upon that plot of land, that's not the type of zoning law that we're talking about here. One example, a noise ordinance. Perhaps you've enjoyed the local Hannibal Square over in the city of Winter Park. you'll notice that those bars close at 1 o'clock. And then you've got to start walking. You've got to head down to Fiddler's Green, or perhaps the Ravenous Pig, or some other place that is going to be open past 1. And of course, I don't speak from experience. I've just been told. That's because there's a noise ordinance in place in Hannibal Square that only applies to Hannibal Square. For that reason, they've got to close up shop a little bit sooner so that those rowdy customers, and again, I'm not among them, I've just been told, can take their noise elsewhere upon a certain hour. That is an ordinance that pertains to a specific activity rather than use of the property. That noise ordinance is not the type of zoning law we're talking about here. Instead, when we look at the zoning map, and what letters do we give this particular plot of land? That's the type of zoning law we'll talk about here. Is this part of plot of land part of this neighbor's zone or this other neighbor's zone? Where do we put it? How do we color it in if we have a color in color? Zoning map. That's the kind of law we're talking about here. For those kinds of laws, which by shorthand I'll refer to now as zoning laws, for those type of laws, there is a particularized notice requirement. The notice requirement works like this. Unlike most laws where we just give 10 days notice, we run it in the paper, we must provide individualized notice for zoning laws. We must tell each known landowner that we're about to pass a zoning law that affects that landowner's land. Now, is that impractical? Is that impossible? Well, no. Why not? Think about this. Land is transferred how? Typically by written deed, isn't that right? And what does one prefer to do with a written deed so that it gives notice to others? One prefers to file the written deed with the county. For the most part, the county already has a list of landowners' names and addresses. Why not force the county to use that list? That's what this particular lawmaking limit forces the county to do. County, you've got the name and addresses of most, or the majority, if not all, of the landowners whose land is about to be affected by this change or enactment of a zoning law. Send them individualized notice, county. That's what this requirement of Florida's Constitution does. What if we fail as a county to provide that individualized notice, but we followed the rest of the procedures? We also gave 10 days notice. We made that notice public. We ran it in the paper. We used the proper form. We complied with the sunshine laws. Well, all of that might be good enough for a law that's not a zoning law. But we have the added requirement of individualized notice. How can you as the litigator use this to be able to go to court and prove? You can't make a law like that. Well, how about this? What if you prove that the county had your client's name and address as the landowner of that spot, of that parcel, of that property, of that land, but your client didn't receive notice? And through discovery, you find that there's inadequate proof, a lack of adequate proof, that notice was ever sent to your client. So with your client's sworn testimony that they didn't get notice, and with the absence of proof that notice was sent, you might have an arrow in your quiver upon which you can strike down Florida zoning law as unconstitutional on its face. And of course, like most of these arrows in the quiver, it doesn't have to do with the subject matter. It's not that this particular piece of land is of a higher value than another, or a lesser value than another, or that your client is of a more protected class than another. That's not what we're talking about. We're talking about how you make laws. You don't make a law like that. When it comes to zoning laws, you send individualized notice. That's a requirement of Florida's Constitution. So we add zoning laws to the big board of lists of arrows in your quiver. We have a question.
What's the qualification of proper form? Can they send it to the mail or does it have to be electronic?
Yes, it has to be mailed. As for the form or format, there's a suggested form or format in the statutes. A wise government will copy and paste. A less wise government might draft their own and hope that litigation doesn't prove that their own drafting is insufficient. But the wise government will copy and paste, they'll use the statutory form, and they'll send it by mail. Does that answer the question? All right. So now, another arrow in your quiver is twofold. There's two different types of inconsistency. Laws might be inconsistent. That happens all the time. Recall from our last lecture when we talked about the first on the list here, when we talked about proper subject matter. There we put and summarized in one slide what was a proper subject matter for the Florida legislature and what was a proper subject matter for local lawmaking. Perhaps you recall that what was proper for the Florida legislature was also proper, for the most part, for local lawmaking. So will there be laws that overlap? Will there be laws made in Tallahassee for the state and then later separate laws made by a county or a city on the exact same subject? Yes, there will. Is that in and of itself enough to strike down one of those laws as unconstitutional? No, it is not. In order to strike down overlapping, if you will, or contiguous laws, if you will, or laws on the exact same subject from different sovereigns, as if you will, in order to strike down such a law as unconstitutional on its face, you'll need to prove that they are impermissibly inconsistent. And in this lecture, we will cover two different types of inconsistencies. One is inconsistency via preemption. The other is inconsistency via conflict. Local ordinances are consistent with general or special law unless state preemption precludes a local government from exercising authority, or unless state action expressly conflicts. So the first of the two we're talking about is preemption. And this is not the first time in our class that we've discussed preemption, is it? Of course it's not. In class 1, lecture 1, hour 1, we alluded to a type of preemption. We talked about the supremacy clause of the United States Constitution versus state constitutions. Generally speaking, which one? Generally speaking, the federal one, right? When, generally speaking, did the federal not win? When the federal said the federal did not win. Right? There are exceptions to every rule, but that was the general rule we learned in that prior lecture. Here now we talk about different sovereigns. We talk about the state of Florida and its lawmaking power versus local lawmaking and its power. Perhaps that local lawmaking source is a county. Perhaps it's a city or a town or a village. In any event, when does one preempt the other? That's the question we're exploring here. Although state law may continue to prevail over conflicting county laws, regardless of whether the county has a charter, charter county laws can prevail over conflicting municipal laws. They prevail whenever the charter county law is a regulatory ordinance. So, if the county is a charter county and the charter county passes an ordinance and that ordinance meets the legal definition of a regulatory ordinance, then that will prevail and preempt over other ordinances of other sovereigns, such as cities, towns, villages, and other incorporated areas within that county. They also prevail on other topics whenever the supremacy clause in the county charter says that the county's laws prevail. And that's a reminder, because when we introduced the concept of local lawmaking, we introduced the concept of a charter, and we talked about the supremacy clause in a charter and how and when it works to preempt. For non-charter counties, they don't have a charter. Therefore, for non-charter counties, county laws do not prevail over conflicting municipal laws. And again, that's a reminder to help you remember. The whiteboard was on this side last time, but I tried to draw the state of Florida, and it was a horrendous drawing. You remember? And then I drew a county, remember? And then I drew a city, and we were all surprised to hear that despite the fact that geographically the city is always either the same size as or smaller than a county. No city can ever be larger than the county it's in, because no city under Florida's Constitution is allowed to have land that exists in more than one county. So by definition, every city is going to be either the same size as or smaller than the county it resides in. So far, the city of Jacksonville is the same size as the county it resides in. Up there in Jacksonville, they managed to incorporate within the city every spot of land that is in that county. For every other city in the state of Florida, the city is geographically smaller than the county it resides in, and necessarily so. Unless they do what the city of Jacksonville did and gobble up all the county's land. So despite the geographic smaller size of the city, for non-charter counties, county laws do not prevail over conflicting city laws. That might be counterintuitive because of the geographic disparity. So maybe for you, that's something you just got to memorize. That's okay. And for those who are memorizing it, let's summarize it again. Oh, you've got a question. Yes, I'll summarize after your question.
Do cities have to be incorporated?
Do cities have to be incorporated is your question? The answer is no. But if it wants legal rights, then it's going to incorporate. So in order to have that municipal existence, the area is going to have to incorporate and thereby become a city. And when it incorporates in that way, it might choose the name city, might choose the name town, might choose the name village, might choose the name The Villages. It's a place here in Florida that literally has that name. So the world is its oyster, so to speak, when it chooses a name. Most choose city. I've been in some really, really, really small places that are called City of. Maybe that's wishful thinking more than it is an accurate description, but it's a legally accurate description because that was their legally incorporated name when that municipality became incorporated. But no, an area can have an existence, but not a legal existence. You know, and somebody was talking about it. I forget who it was. I don't know why they admitted it, that they like to go drinking in Hannibal Square, and then they got to find another bar even after it closes. Who was that? Who was that talking about that? I don't remember who that was. It doesn't matter. I'm sure whoever it was is a good, honest person. So, but Hannibal Square is not incorporated. It's a beautiful area. The city's taken the time to put an obelisk or a statue in an obelisk shape that marks the four corners of Hannibal Square. And I'm glad they did that, so you can see where it begins and ends. But other than that, it doesn't have a legal existence separate from the city of Winter Park. Indeed, it can't have a legal existence separate from the city of Winter Park because it's surrounded by the incorporated area, and it itself is among the incorporated area of the city of Winter Park. So that's already been done. It's already incorporated, and it's called Winter Park. But within Winter Park is Hannibal Square. Likewise, in the city of Orlando, which is adjacent to the city of Winter Park, there's lots of neighborhoods there. Another great neighborhood is Audubon Park. Anybody been to Audubon Park in the city of Orlando? And again, we know it is Audubon Park. We stop by there. So we enjoy the Kelly's ice cream and other great sights. What's the name of the sushi place in Audubon Park? Great sushi. What's the name? No? No sushi lovers here? Admit it. You like raw fish. But that town certainly has a personality. That area certainly is a neighborhood. It certainly has a culture, whether it's Audubon Park or whether it's Hannibal Square. But it's not legally incorporated. Audubon Park is the city of Orlando. Hannibal Square is the city of Winter Park. So have I answered your question? Okay. I guess the quick answer was no. But you got the long answer. Hope it was somehow helpful. So to summarize, there's a type of inconsistency that is an arrow in your quiver that will strike down legislation as facially unconstitutional under Florida's Constitution. That particular type of inconsistency is called preemption. Although state law may continue to prevail over conflicting county laws, regardless of whether the county has a charter, charter county laws can prevail over conflicting municipal laws. They prevail whenever the charter county law is a regulatory ordinance. They also prevail on other topics whenever the supremacy clause in the charter of the charter county says it prevails. For non-charter counties, there will not be a charter, therefore there will not be a supremacy clause. Therefore, generally speaking, county laws do not prevail over conflicting municipal laws. Does the summary make sense? Any questions about this? One of two types of preemption. One of two types of inconsistency. So this first type of inconsistency is called preemption, but that's not the only type of inconsistency. Another type of inconsistency that we'll talk about is a conflict of laws. Now, when is a conflict of laws so impermissible as to render that law unconstitutional on its face? The Supreme Court of Florida has answered that question. There is a test that determines whether or not it is unconstitutional on its face. The test is this: if you've got to violate one law in order to comply with the other law, then you have a facially unconstitutional conflict of laws. Think about it. That's simple. That's a standard we can all grasp, right? If by obeying the one law, I am disobeying the other law, then that's an unconstitutional conflict of laws. If I got one law that tells me to do this, and the other law says, hey, whenever you do that, that's a law violation, those two laws are an unconstitutional conflict of law. Got it? Another way to say the same thing that I just said is that a municipality can't forbid what Florida's legislature says is okay. There's a lot of different ways that the legislature can say something is okay. One way is it could say that it's licensed. If you can get a license to do such a thing from the Florida legislature, then it's an impermissible conflict of laws for the county to say it's illegal to do that thing. Let's think of a crazy hypothetical example. What if the lawyers were unpopular and Orange County had enough and said, practicing law within Orange County is a misdemeanor? Well, we know that you can get a license to practice law in the state of Florida, right? And we know that Orange County is within the state of Florida, right? Therefore, in my crazy hypothetical where Orange County said it's a misdemeanor to practice law here in Orange County, that would be facially unconstitutional, because you would be in a situation where there's a conflict of laws that is inconsistent and insufficient under Florida's Constitution. Another way the legislature might say it's okay to do something is to either authorize it or, one step further, to require it. So if Florida's legislature says you must do this, and then the county decides it's a sanctuary county, we're free of all the people who do this, it's not allowed to do this here in this county. But the legislature already said it's required to do this. Now that county law is facially unconstitutional because that's a conflict of laws. That's an impermissible inconsistency. That's the kind of example where this arrow in your quiver will strike down that legislation. You can't make a law like that. So does that give us an adequate discussion of what we mean by those two types of inconsistencies? Do we understand where I'm coming from on there? And if you need more, we've got our case book. I've given you these laws, but not in the form of going over the case law precedent. But of course, you've seen the cases in the book. For these arrows in your quiver where you need more practice, you got to dive into those cases. You got to read them and try to understand them. I know at least 4 of us have read them and read them well because I got a great email from our 4 lead counsel, and they provided us with, I believe it was 10 pages long, of a summary of this chapter. And I thought it was well done. If the website's back up, which I hear it is a book fell down. Website up, book down. Things happen. Is the website back up? FLAconstitution.com? All right. So go ahead.
But the new slides are not on there.
Okay, but what about the outline? If you click outline, does it come up? Come on, man. I was trying to quote a famous politician there with the come on, man. Yeah. No, not there. All right. Well,
It just shows it for class 3, but
what if you hit refresh? Fingers are crossed. Refresh is being hit. Come on, man. Hey, that worked. All right. All right. You never know. Sometimes it's new batteries. Sometimes it's a refresh button. You never know. And who knows, maybe that television will work someday. What's going on with that television? If you weren't here early like I was standing on a chair trying to get that thing to work. I mean, I've complimented this beautiful room so many times. Why is it fighting back against me? I don't get it. I don't get it. But it's not about whether I get it. It's about whether you get it. Here's the big board. Do you get these arrows in your quiver? Do you see how you could use them to strike down as facially unconstitutional a Florida statute or a local law that maybe your client genuinely violated? Maybe your client is a no good, dirty, rotten lawbreaker. You can get your client off. You can beat the rap if instead you can strike down the legislation, right? Well, I hope this all makes sense to you. Let's take our 5-minute break because when we come back, I'm going to find out whether this makes sense to you. That's right. I'm going to put you to the test if you don't mind. Here's the question to be answered. If you were staring at the face of a law that violated one of these limits upon Florida lawmaking, would you be able to identify that violation? Let's find out, shall we? Here's what I'll do. I'll make them crazy, hypothetical laws. I'll put them on the big board. And then I'm going to ask you, does that law violate any of these arrows in your quiver? Sound like fun? Oh, I knew you'd love it. Well, let's take our 7 minute, 8 minute. How many minutes you need for a break? I'm hearing 30. That's generous. That's generous. Yeah. Let's go with 7, shall we? It's a few minutes shy of 30. I'll see you back at 7 minutes, and we'll play the lawmaking and its limits game. See you then. How was the break? Good break? Give me a break. Give me a break. Had a good break. It was less than 30 minutes. Sorry about that. All right. And we can't neglect our lead counsel because our lead counsel don't neglect us. We appreciate that, right? So I thought I should have acknowledged the awesome contribution of last week's lead counsel. So better late than never, right? Connor, Alex, Dan, the three of you. Yeah, three of you here today. Who thinks Connor, Alex, and Dan did a great job last week like I do? Thank you. Thank you very much. All right, appreciate that. And this week for lead counsel, we've got 4 authors, and the website's up. I found it. It's over there. One website, it's up, so you can see the work of our 4 authors. Great job. Anybody here check it out yet? Who agrees with me that was a great job? Let's give a hand to our 4 authors. Thank you. Thank you very much. And then we've got one lone lead counsel today who says, here I am. Who says, it is I, your class spokesperson. Alejandro, are you here? Yes. At this point, you want to run out of the room, I understand. No, but let's in advance give a hand to Alejandro. Please tell me I pronounced your name correctly.
Yeah.
Thank God. I hate, I get McKinley all the time. I get McGinley, which makes sense because it's spelled G-I-N and so is gin, right? But yeah, everybody wants their name to be properly pronounced, so hope I did that. Yeah, all right. So now, with our lead counsel in the lead seat where lead counsel belongs, I posed the question not just to lead counsel, but to all of us. And that question was, if you were staring at the face of a law and somehow that law violated one of these arrows in your quiver. You've got them here on the big board. Maybe you've written them down by now. If you haven't, this is a great time. I often, at seminars nowadays, see folks tear out their cell phone and zoom in and take a picture of the slide. Maybe that's not necessary here because I tend to post the slides on our website for you. So, and if you're bored and you're suffering from insomnia, you can even use that website to go back in time and see past slides, past lectures. There's a past midterm exam on there, about 2 clicks to the right. Just depends on how much insomnia you've got as to how deep you want to go into our website there. If you go deep enough, you'll fall asleep. So all that is there. But I hope I bought you enough time if you hadn't written down the big slide here yet, or to at least take a picture of it or write it down. Because now we're going to use that knowledge. Our lead counsel will guide us. Here's how we'll play the game. Here's how we'll find out. Here's the rules of the game. And of course, if the rules don't make sense, I need to know that so I can clarify them. So let's go over the rules here. We're going to give you a series of hypotheticals. These facts are common to all of the hypotheticals. Orange County is a charter county in the state of Florida, okay? The city of Winter Park is an incorporated city located within Orange County, Florida. Got it? Here's the kicker. Because remember, at some point I got to illustrate preemption, right? So, laws duly enacted in a preceding hypothetical remain the law applicable to a later hypothetical. So they're in chronological order, so to speak. Hypothetical 1 was enacted, and then days or weeks or months later, hypothetical 2 was enacted, then days or weeks or months later, hypothetical 3 was enacted. And you see why I got to do that. If I'm going to have some sort of preemption or conflict of laws, I got to have more than one law, right? So you see why I made up these rules of the game. Alejandro, you're willing to play by these rules, sir? All right. And you don't have to answer these alone. And you don't have to phone a friend because you've got, 52 friends right here. Come on, let's be friends. Why can't we be friends? I'm singing a lot today. Days like this, I wish I had a good singing voice. All right, let's take a look at the first hypothetical, shall we? All right, hypothetical number 1. Let's say it with enthusiasm. Hypothetical number 1. Let me hear some cheering. Yeah. All right, hypothetical number 1. Here it goes. Be it resolved by the Orange County Board of County Commissioners that whenever the Amway Arena hosts an event that sells more tickets than the number of Amway Arena parking spaces that are available at Amway, Amway will pay the county 5 cents per ticket to compensate the county for expenses the county incurs due to the increase in arena area parking. How about that? Be it resolved by the Orange County Board of County Commissioners that whenever the Amway Arena hosts an event that sells more tickets than the number of Amway Arena parking spaces that are available at Amway, Amway will pay the county 5 cents per ticket to compensate the county for expenses the county incurs due to the increase in arena area parking. Interesting. Let's brainstorm. Let's think out loud, right? It's a constitutional law class, so, oh boy, this is, how about some strict scrutiny? I don't know, is this kind of law you'd subject to strict scrutiny? Where's the personal human right that's being violated here? I'm taking nickels from a corporation. Okay? All right, so maybe not strict scrutiny. Is there a permissible government objective here? Oh, your hand's up, yeah.
Well, just a fun fact, there is no Amway Arena parking, so.
Oh, wow, okay. They don't have any parking?
No.
Oh, okay. Let me add another rule to the hypotheticals. Hypothetically, the Amway Arena has a parking lot. Thank you for pointing that out. Yeah, all right. Yeah, okay. Oh, lead counsel has the answer. Lead counsel, thank you. To the rescue. Hey, your shirt says mock trial. Go Knowles. Yeah, no doubt, no doubt. That was the Seminole symbol. Yeah, there you go. There you go. Yes, fellow Seminole. Respect. Yeah. We don't always pound our chest. I just felt like doing that. I'm sorry, lead counsel, I'm talking all over you, man.
The problem here is that they're looking at.
There's a problem here, lead counsel says. So far, I agree. All right, go ahead.
They label it as be resolved.
Whoa. Whoa. I'm going to stop you right there, lead counsel. I'm trying to talk about strict scrutiny, rational relationship. Is there a permissible government objective? Is it rationally related? What's lead counsel over here hemming and hawing about? The 3 words in caps, be it resolved? Man, this is what you got for lead counsel? This is the example? This is the answer you're giving me? Who's going to raise a hand and say lead counsel is correct? Raise your hand if you want to be correct. Lead counsel is correct. Yeah. Well done, Mr. Lead counsel. Yes, exactly. What do we call local law that begins with the enactment phrase, be it resolved? A resolution. What's the other type of local law called? Ordinance. When is an ordinance required? Lead counsel is going to tell us, go ahead, man, you're on a roll. You're absolutely right.
For a resolution, it's a temporary thing, but this would be a permanent thing.
So a resolution, one example, is a temporary nature, right? Or an administrative task. But something that can't be resolved because a resolution is insufficient is what?
An ordinance.
An ordinance, which is something of a permanent nature. Now, I didn't say I was going to borrow these nickels and then hand them back to Amway, did I? No. Amway will pay the county 5 cents per ticket. And even if it said Amway will loan the county 5 cents per ticket, I believe we'd still have the same facial flaw. What you're looking at on the big board, thank you, lead counsel, because you're absolutely correct, and you weren't persuaded by my hemming and hawing. What we have here is a violation of that arrow in our quiver, the one that's in bright highlighted yellow, the one that says ordinance versus resolution. That's the violation illustrated by hypothetical number 1. Why is that what's illustrated? A resolution cannot be substituted for and have the same force and effect as an ordinance. An ordinance is how one passes a local law of a permanent nature. And that was permanent. Lead counsel, well done. All right. So far, okay. Lead counsel. One. McGinley. I was going to put 0, but I'm going to go with -1 because I didn't know that Amway didn't have a parking lot. So, keeping score on the scoreboard. Lead counsel 1. McGinley's in a deficit with -1. Let's see if I can make a comeback. All I got to beat is lead counsel, who apparently is very talented. And lead counsel's 51 francs. Let's see what I can do here. Let's look at hypothetical number 2. And remember the rules of the game, right? This is Florida in our hypotheticals. When we talk about Orange County, we're talking about a charter county within Florida. When we talk about Winter Park, we talk about an incorporated city within Orange County within Florida. And law number 1, we presume, remains on the books and was enacted before hypothetical number 2. Now, remembering hypothetical number 1, remembering the arrows in our quiver, let's look now at hypothetical number 2. This is section 681-2700, which happens to be my phone number. I'm your friendly neighborhood bar grievance defense attorney. If you have a license to practice law and would like to keep it, call 407-681-2700. I will come to your defense. Section 681-2700 Florida statutes reads as follows. Be it enacted by the Florida legislature, yada, yada, yada. Number 1, it is the intent of the Florida legislature to protect school children from convicted felons wielding baseball bats. Scary. Scary. Number 2, the state hereby preempts to itself all laws regulating a convicted felon's use or possession of a baseball bat. Number 3, and you've had laws read out loud before. It's always with this type of enthusiasm, right? Yeah. Number 3, no convicted felon may hold, possess, or be given a baseball bat while the felon is within 1 mile of a Florida school. Number 4, no zoning map may permit a business selling baseball bats to be situated within 1 mile of a Florida school. I think I'm going to stump lead counsel here. I think so, because the knowledge lead counsel needs was in the readings, but not in the lecture. So let's not leave lead counsel hanging. Oh, BJ's got it. Oh, and another hand. When thinking out loud, let's not consider each one of these as an answer. Let's hear from both of you first. Yes, BJ, go ahead, go first.
The problem I see with number 4 is they would have to give notice to everyone that lives within 1 mile of any Florida school because it's a zoning law. So it doesn't say that they did or did not give notice. So that's hard to roll, but that's just.
All right. Did everyone hear BJ's concern? And it was a good one, right? When it comes to a zoning law, right, individualized notice is required. Our hypothetical didn't explicitly state that that type of notice was provided. All right, but thinking out loud, your statement of the law is certainly correct. Let's keep thinking further because we've got another hand. Yes, sir?
In Florida, zoning laws for provinces, counties, cities, towns, and villages, but not the Florida legislature. Therefore, the Florida legislature is not an power to pass Florida.
I never said that in my lecture. Say that to me slowly so I can repeat it back for all.
In Florida,
Zoning laws. I'm sorry, I'm the English to English translator. What was the English there? In Florida, zoning laws are the province of counties, cities, towns, and villages, but not the Florida legislature. Should I trust that source? Who's the author of your book, sir? I understand he's kind of short. And at least in this instance, he's kind of correct. Lead counsel, I turn to you now. Sounds good to me. Lead counsel says it sounds good to me. Yeah, there's certainly a flaw here. And I don't disagree with BJ. Her statement of the law is correct. And much like the lack of assuming that Amway has a parking lot, oh man, maybe the hypothetical should have pointed out whether there was individualized notice. We'll give McGinley a -2 on the big board. But at the same time, we got to find out whether lead counsel gets a +1. Lead counsel says it's facially unconstitutional because paragraph 4 affects a zoning map through a state statute that was enacted by the Florida legislature, which lead counsel says, give it lead counsel credit, that's okay. You're okay. Okay. Which lead counsel says, I was whispering there, no one can hear that. Which lead counsel says is not within the lawmaking power of Florida's legislature. Here in Florida, lawmaking as to the zoning map must be done on the local level. How about that? Hey, hats off to subsidiarity. You ever heard that phrase before? People are like, oh man, he's going there again. But you got a graded essay on that topic, so I might as well go there so I can help you do the essay, right? Hats off to subsidiarity on this one. We've actually empowered the lesser sovereign, have we not? Have we done it in a wise way? We've said that the zoning map should be enacted by the local legislature instead of the statewide legislature. Do you agree? Is that wise? Maybe you agree it's wise. Maybe you say, no, that's not wise. But whether you say it's wise or unwise, you got to say it's certainly an example of subsidiarity in action, right? Because we've empowered the lesser sovereign. And the greater sovereign hasn't quashed it and made it irrelevant. There's my subsidiarity tangent. Back to the main issue. Is this law unconstitutional on its face? Yes. What is the flaw? It's subsection 4. What is this flaw in subsection 4? It is a zoning law. And since it is a zoning law, it cannot be passed by Tallahassee, by which I mean it cannot be passed by Florida's statewide legislature that presides in Tallahassee, by which I mean Florida's Constitution reserves zoning law and lawmaking power as to zoning solely to municipalities, be it counties or cities or towns or villages or the villages. So so let's give lead counsel another point. The gap is widening. Lead counsel 2, McGinley -2. Shall we go forward? Shall we see what else we've got for the hypotheticals? Man, the energy in this room is off the charts. Calm down, y'all. Let's go to hypothetical number 3. Alejandro, you ready? All right. I mean, your undefeated nature, your undefeated score is on the line. You're like Tom Brady, Super Bowl champ, going back for Go Bucks for another season. You ready for this? All right, he's ready. Have his back. All right. Hypothetical number 3. This is city code 1234567, which is not my phone number. City code 1234567 reads, in relevant part, be it enacted by the city of Winter Park, Florida. 1, it is the intent of the city of Winter Park to entice Major League Baseball teams to practice spring training here. Oh, that's fun. Huh? 2, in furtherance of that goal, March is declared Free Baseball Bat Month. See where we're going now? Number 3, every March, any Winter Park resident may visit the elementary school nearest the resident's home to pick up a free baseball bat. And number 4, just in case you missed it, no Winter Park resident may be denied a baseball bat on the basis of race, sex, or prior criminal conviction. Wasn't there a state statute on the books that has something to do with baseball bats? Lead counsel, what you thinking here?
Right now, I'm kind of leaning towards,
You're skimming the big board, you're looking for some potential. And of course, we don't leave our lead counsel hanging. It's not the kind of law firm we are, right? There's a hand up. Yes, speak to us. We're thinking out loud right now. We haven't answered the judge yet. We're brainstorming. Go ahead. Help us brainstorm.
would this would be in violation of the Constitution when it says that.
I like where you started. You're going to a constitution. It's a con law class, a good source. Like it.
And it says that a city can make laws.
Yeah. That's true under our constitution. And city has lawmaking powers.
Yeah,
Might even have home
that
rule
is
power, right?
not inconsistent with the other laws.
Ooh, I like the phrase you just used. That might have been a double negative, but it's a double negative that came from the case law, right?
Yeah,
Can make laws that are not inconsistent with. Go on.
with other.
I know you've been wanting to go on. I keep interrupting, but please go on.
With other pre-existing laws, and so we just saw the pre-existing law that says that convicted felons can't be near, I don't know how far, but can't be near a school, and this is telling you to go to a school to get a baseball bat.
Yeah. Yeah,
So
lead
it
counsel,
could be a criminal conviction.
isn't this wise? Isn't everything we just heard correct? Doesn't this lead us down a particular path toward one of the arrows in our quiver? Does anybody see which arrow in our quiver might be the weapon here that can strike through the heart of this legislation and render it facially unconstitutional? Lead counsel?
I think that's definitely a good one here. I totally forgot for a second about the.
Well, that's okay. You want to think it through because you want to be consistent. You don't want to be inconsistent. There was a hint in there. There's a hint in there.
Yeah, I mean, this is definitely consistent.
There's a consistency problem, is there not?
Right.
Yeah. But the question becomes, is it one that's rendering this law unconstitutional? Maybe it helps to look at the prior law, right? Here's this law, okay? We read it out loud just a second ago. This is City Code 1, 2, 3, 4, 5, 6, 7. But don't forget, state statute, Florida statute 681, 2700. Check out subsection 2. Who will read for us out loud subsection 2? Okay, I will. Nobody laughed at that. Okay. The state hereby preempts to itself all laws regulating a convicted felon's use or possession of a baseball bat. Keep that in mind while we look again at the language of City Code 1, 2, 3, 4, 5, 6, 7. It has to do with baseball bats. Has to do with the use and possession of baseball bats, right? What did Florida's legislature do with regard to laws about the use and possession of a baseball bat? Yes, let's think out loud. Let's help lead counsel. Go ahead. They preempted it. Is it so? Lead counsel, you get to give the final answer. Is this an example, City Code 1, 2, 3, 4, 5, 6, 7, of a facially unconstitutional local law because of an unconstitutional inconsistency via preemption?
Well, even though it wasn't consistent, it was preempted anyway, so. Yes.
Yeah, your answer is yes. Lead counsel says yes. Who raises their hand and agrees with lead counsel? Who wants to be correct? Raise your hand. All right, there you go. Yes, that is the correct answer. I was attempting with these hypotheticals to illustrate an inconsistency that is unconstitutional due to preemption. It's a hand up in the back. Yes.
Because zoning laws by the legislature are invalid, didn't we strike that part of that statute?
Yes, on our rules of our hypothetical, we're presuming that the prior hypothetical remains on books. So I kind of made that one of the ground rules. But you're right, I'm striking down law after law after law. So you're right to ask yourself, well, I struck down that prior law, so I have to worry about it now. But under the rules of our hypothetical, for this game of ours, I'm pretending those those laws stay on the books. So well done, good thinking, but I'm playing the game with these kind of game rules, ground rules, if that's okay. Okay, yes, another question?
As a practical matter, though, if it was unconstitutional, is it just part of the law that would be struck down or the whole law?
You didn't like that answer.
Right.
Yeah, that was a pretty lame answer, right? Why is McGinley up here dodging questions? That's not right. You know, if I'm a politician, then that's my job to dodge questions, but I'm not. I'm teaching a class. So yes, to rephrase your question, go ahead and do it again. I'll answer directly.
If it's struck down because it's unconstitutional, is it the whole law or just the parts that are unconstitutional?
Yes, let me answer that question as to a Florida statute. In a Florida statute, to answer the question of if part of the Florida statute is unconstitutional, does that mean the entire law falls? The answer might be different in federal. That's why I say that my answer is for Florida. What Florida will do is determine whether the unconstitutional portion of the statute can be excised from the statute. The judges finding the unconstitutionality will make that determination at the same time. If it can be excised and the law therefore can remain, then it will. If it can't be excised without a functioning law, then there are other remedies available within the state of Florida, which may or may not be available under federal law or other state laws. For example, if the language that is excised as unconstitutional was itself an amendment of that law, then the court can reinstate the law as it was prior to the amendment. So to answer that question completely, I feel I need to give an example. Let me see if I can use this hypothetical on the billboard to do that. Here we know that subsection 4 is unconstitutional, but subsections 1, 2, and 3 are not. At least that was our hypothetical law and our hypothetical answer. If this were a real law and you'd be before the court, I think, looking at this law, the courts would agree that we can still have a valid and functioning statutory scheme with just numbers 1, 2, and 3, and without number 4. So I believe under Florida law, for this particular hypothetical, the answer would be that subsection 4 would be stricken as unconstitutional and therefore unenforceable, but subsections 1, 2, and 3 would remain on the books and would remain enforceable. Of course, that's the easier scenario. To look at a more difficult scenario, we'll see in a later chapter a particular case called Westfall versus City of St. Petersburg, which I use for making another point, but I'll draw upon right now to make this point. Under Westfall, the law had said that an injured worker was entitled to 401 weeks of the combination of temporary total and temporary partial disability benefits under Florida's workers' compensation law. That had been the law prior to, I believe it was 1993. A subsequent amendment changed that cap to a cap of 104 weeks. In the decision of Westfall versus City of St. Petersburg, which I think was around 2016, if I remember right, the Supreme Court of the state of Florida held that the 104-week cap was unconstitutional for reasons we will talk about in greater detail when we get to that particular constitutional provision later in this class. But for now, I'll note that since the 104-week cap was unconstitutional, and it was an amendment to the 401-week cap, the remedy awarded by Florida's Supreme Court was to find 104 weeks unconstitutional, find the Florida workers' compensation law as a whole to remain on the books and enforceable as constitutional, but to read into it, to reenact, if you will, the 401-week cap. So as we sit here today in the state of Florida, an injured worker has a maximum of 401 weeks of temporary total and temporary partial disability benefits, even though if you open Florida Statute Chapter 440, subsection 15, it will clearly tell you that the law says 104 weeks. But the judicial remedy was to say that we read that law as it was before the unconstitutional amendment. So sorry to go off on a long tangent. You had asked the question, I dodged it. You re-asked the question, I figured I better answer. Now did I finally answer it?
Yeah.
Okay, all right. Sorry to try to dodge it. And I like that. Hold me accountable. I shouldn't be up here dodging questions. Thank you. Yes, you've got a question. Sorry, I'm dodging it. Just kidding. Go ahead. Answer your question. Just kidding. Go ahead.
Section 2 was not in this board legislature. Would it still be unconstitutional because of conflict, or do you just automatically assume that because it's already?
You hold my feet to the fire. I love it. You're asking, what if this hypothetical didn't have subsection 2? Subsection 2 is where I went so far as to say, the state hereby preempts to itself, right? So in my hypothetical, by using that language, the state hereby preempts to itself, I was giving an example of express preemption.
So you can do implied preemption.
There is also, just as you said, there is also a type of preemption called implied preemption. So preemption can take two forms. Here's the blatant one, the express preemption, but another one is implied preemption. How do we know whether there's implied preemption? The awful answer to that question is when a court tells us there is. But that's not a very good working definition for us lawyers when our clients are asking us, is this a case of preemption? So what we must do then is apply the legal standard. And in Florida, which may be different in the federal, in Florida, the answer is this. If the legislation that doesn't contain an express preemption clause nevertheless so fully occupies the field as to show a legislative intent to preempt, and it is so fully occupied the field that by adding local legislation, you would be contradicting the legislative intent. If both those things are true, then you have a case of implied preemption. How can you be sure that those two standards are met? Well, you never can be sure until it's litigated and adjudicated. But your client only wants to hear so many times, well, we don't know until we go to court. You know, your client wants some kind of actionable answer. It's hard to have a definite confidence in an actionable answer as to whether under Florida law there is implied preemption, which is why when I wrote the hypothetical, I went with express. There's method to my madness. There's also a lot of madness to my madness. Yeah. But did that answer the question?
I think so. I think I was just asking because if that was out there, you have to, or if it was taken out, you would have to find implied preemption, or could you just apply conflict of law and say that it's still unconstitutional?
Oh, okay. That's a different question. I'll answer that one too. There were those two types of inconsistency. That were my examples of inconsistency that made the law facially unconstitutional. One was preemption. And that's what I'm illustrating here through express preemption. And as we just discussed a minute ago, I could have illustrated it, or I could have tried to illustrate it through implied preemption. But there is that other type of inconsistency that's not preemption, that's called conflict of laws. That is more than just two laws addressing the same topic. You can have two laws address the same topic. That's okay. That's not on its face unconstitutional. It's not unconstitutional on its face for the Florida legislature to see a problem, pass a law, and for a local legislature such as a county or a city to see the same problem and to also pass a law. That's not enough to say that there's a conflict of laws. It's got to be this extreme in order to satisfy conflict of laws. My behavior in complying with one law is a violation of the other law. Look, we all want to obey the law, right? By obeying the law, should I be disobeying the law? What? McKinley, you're talking out the side of your neck. No, I'm trying to give an example of what extreme we need in order to have a facially unconstitutional law under Florida's Constitution that satisfies the requirements of inconsistency by conflict of laws. If one law's good and right and required behavior is an example of a violation of the other law, then we have a conflict of laws. If in order to obey one law, you violate the other law, now we have a conflict of laws. So you see that standard, you see how extreme that is. If I'm a good law-abiding person and my good law-abiding behavior is a violation of somebody else's law, then we have a conflict of laws. So with that legal standard in place, the answer to your question is no, that wouldn't be a violation of conflict of laws that we see here. It's a violation of preemption, but it's not a violation of conflict of laws.
In relation to hypo 3 though,
Oh, yeah, yes,
with hypo 3,
hypo 3.
this is 2.
Oh, okay, yeah, got to keep track. That was, yep, that's hypo 2, the state legislature. Hypo 3 is the city code. Yes, your question.
Section 2 in the last law was not in there, the one that preempted.
Oh, subsection 2 just declares a free baseball bat
Right.
month.
So
Could have done that by a resolution, right?
would subsection, I believe 3 here conflict with subsection 3 and 4 of the previous law?
Absolutely, yes. There's the conflict. Correct. And you heard the question. Here is subsection 3, the conflict with the state statute. Is subsection 3 of City Code 1, 2, 3, 4, 5, 6, 7 a conflict with Florida Statute 681, 2700? And the answer is yes. That is the conflict. And that conflict is preemption. It is a conflict of inconsistency. And what makes that inconsistency unconstitutional under Florida's Constitution is the express preemption. So the answer is yes, and that's why the answer is yes. So I didn't dodge that question. All right. BJ, yes.
So as a matter of practice, because that was kind of the same line of question I was thinking about.
Yeah.
So as an attorney, if you felt like, say we get to this point, okay, there's a preemptive issue, but there's also now a conflict of law issue, would you bring both counts? Like, would you?
Well, conflict of law is a form of preemption.
Okay,
No, I'm sorry. Conflict of law is a form of inconsistency.
right.
Yes.
So would you?
So you're saying, your question is, if I, the litigator, suspect both a conflict of law and a preemption, do I raise both? Under Florida law, the answer is you can raise both if you do so in a pleading with a good faith basis. So you're allowed to assert a good faith basis for a change or modification of existing law. Here, you've got a clear example of an inconsistency by preemption. So you can raise that. It's ethical to do so. If you premise your point of raising conflict of law with the explanation to the court in your pleading that you're making a good faith argument for a reversal, extension, or change in existing law, then you could do that ethically also.
And does that work the same for the other things on the list? Like you could do multiple things on the list?
Oh yeah, generally speaking, Florida law does allow the litigant to plead in the alternative, just as the federal rules of civil procedure do. So your limitations upon pleading in the alternative are your ethics, are your rules regulating the bar. You have to have a good faith basis for bringing that claim. For all those claims that you can have a good faith basis in bringing, you could bring in the alternative. Now, Florida law is like federal law in that the lawyer is the person who decides how to achieve the client's objectives. The client has the ultimate say as to what the objective of the litigation is. The lawyer, while furthering that objective, has the right to decide the means by which to achieve that objective. So perhaps your client came to you and said, hey, this is an attorney-client privilege conversation. Don't repeat this. But yeah, I violated City Code 1, 2, 3, 4, 5, 6, 7. I'm as guilty as can be. Here's what I want you to do. Strike it down as unconstitutional. All right? Now, at that point, do you have to throw everything at this law? Do you have to raise every possible argument? Do you have to make every colorable claim of unconstitutionality? And the answer is no. Your client has given you an objective to achieve. And if you've accepted the representation, then you've accepted that objective. Here, the objective was prove this law to be unconstitutional and keep quiet about the fact that I'm as guilty as can be. So you keep quiet about the guilt and you attack the constitutionality, but you don't have to raise every colorable claim of unconstitutionality. You can, using your professional judgment, decide, well, you know, I don't want to go in there with 7 arguments. And argument 1 gets shot down. Argument 2 gets shot down. Argument 3 gets shot down. Argument 4 gets shot down. Argument 5 gets shot down. Argument 6 gets shot down. And now I'm standing up there with argument 7. What's everybody expecting that argument to have? They're expecting it to get shut down, right? Maybe you think it makes for a more powerful presentation to abandon the other 6 and simply take the one that can't be beat. As the litigant, you can choose the means by which you advance the client's objectives. So I hope that answers your question.
It did.
All right. Did I miss any questions? All right. So now we got another problem. I'm losing by a lot to lead counsel. I got to make some headway here. Maybe we can stump Alejandro. Can we do it? Let's give it a shot, shall we? We're up to hypothetical number 4. Hypothetical number 4. You ready? Come on, tell me you're ready. Can't hear you. You sound ready. All right, here it comes. Hypothetical number 4. Statute 8675309. 86753. I'm singing way too much in this class. Being enacted by the Florida legislature. 1. This law will be known as the Florida Right to Work Act. Oh, okay. 2. No Florida employer may lay off an employee before giving the employee 30 days written notice of the layoff. Okay. Number 3. No Floridian may engage in political lobbying before registering with the Florida Secretary of State. I saw that. You're like, what? You may be onto something. You may be onto something. Number 4. This law expires at noon next Tuesday. All right. McGinley must have been a Hannibal Square when he wrote this hypothetical. Nobody laughed it down. Okay. Because you're all worried about me hanging out at Hannibal Square. Is that what? Okay. All right. So here's our hypothetical number 4, right? It was enacted after hypothetical 1, after hypothetical number 2, after hypothetical number 3. Okay. And we're pretending hypotheticals 1, 2, and 3 remain on the books, good and valid. Let's talk it out. You've got your hand up. Let's talk it out. Let's brainstorm. Go ahead.
So this is more than one purpose.
Yeah. And as I read the third purpose, I saw we're seeing more than one purpose, or stated somewhat differently, more than one subject here, right? We've got the Florida Right to Work Act. Technically, that's not the type of title we use when we talk about title requirements, but bear with me here. Might have to use that later. No Florida employer under number 2 may lay off an employee before giving the employee 30 days written notice. All right, so 1 and 2, right? I got a Florida Right to Work Act, and then I got can't lay me off unless you do something. So I have a right to work until you do something. Okay, sounds like we're on a subject here. We're on one subject here, right? The number 3 says can't engage in political lobbying before registering with the Florida Secretary of State. The number 4 says the law expires at noon on Sunday. Lead counsel's chomping at the bit. I see your hands up. Like there's no more discussion to be had. Like you're gonna what they call it when one runner goes so fast that they get all the way around the track before the other runner does. You're gonna lap me. You're gonna lap me here, man. All right, what you got?
I mean, I was definitely thinking single subject because I don't know how you could logically tie. Yeah, the connection has to be natural, logical. There must be a reasonable explanation for how the provision is necessary to the subject,
Right.
and effective or promote objects and purposes of legislation, including subjects. I don't really know how that would be a natural or logical conclusion to say, well, no one can lobby before the Secretary of State.
Yeah.
This is completely about employment.
Right? Lead counsel is confident. Lead counsel is saying there's a single subject rule violation here. I mean, lead counsel must be stretching, right? I mean, the U.S. Constitution doesn't even have a single subject rule, right? I haven't seen the news yet today, but last time I heard they were trying to spend, what, 3 trillion, 8 trillion, 400 trillion? I don't know. Numbers getting large. And they seem to be buying everybody off. You know, we'll build you a bridge. We'll build you an an airport. We'll build you I don't know, nicer house. Single subject rule, that's like unique to Florida's constitution. That's really going to render this unconstitutional? Yes. Is it? Yes.
Because it says it expires next Tuesday.
Oh, before we get to that, you're about 1,000, man. Just drop that. Drop that. Okay, so lead counsel dropped that argument. And lead counsel says this is a single subject rule violation. This law right behind me is unconstitutional on its face for failing to address a single subject. Raise your hand if you agree with lead counsel. If you say yes, come on, raise your hand if you want to be right. Raise your hand if you want to be correct. Everyone's hand is up. Everyone's hand is up, yes. And you are correct. I have illustrated here a single subject rule violation. That's why I highlighted here on the big board. The single subject rule has been violated. Both the Florida Constitution and Florida's Municipal Home Rule Powers Act provide that each ordinance or resolution shall embrace but one subject and matters properly connected with that subject. The ordinance or resolution may include every matter germane to and not inconsistent with or foreign to the general subject of the law as expressed in its title. And subsection 1 technically wasn't the type of title we're talking about, but let's just run with that, okay? What am I supposed to do? Make a slide with 8-point font? So I've got one of those 90-line titles for you. That would bore you to death. So just bear with me that was the title, okay? So long as the matters addressed in the act are fairly related to the subject described in the title is constitutionally sufficient. So we've got a violation here of the single subject rule here in hypothetical number 4. Number 1 is for our purposes, okay, for our hypothetical, only so many characters per slide purposes. We've got a title of Florida Right to Work Act, okay? And certainly number 2 is establishing a right to work. Number 3 seems to have little or nothing to do with that. One might even be able to argue that number 3 says you don't have the right to do that type of work, right? So that's clearly a single subject rule. Now, lead counsel considered but ruled out saying that there was a violation in subsection 4. Check out subsection 4. This law expires at noon next Tuesday. Can a law in Florida have an expiration date? Can it apply for just a stated period of time? Can it, by its face, expire? Answer to all those questions is yes. Yes, a law can expire on its face. A law can apply for just a stated amount of time if that's a Florida law. That's okay under Florida's Constitution. Now, it would be very unusual, granted, for any Florida legislature, whether it's the Florida legislature in Tallahassee or the Board of County Commissioners or the City Council, to use language like expires at noon next Tuesday. But at least under the legal standard, they could. And I did. So no violation there. All right, so let's give lead counsel a point. As best I can tell, I had no reason to lose any points on that one. Everyone agree? Oh, your hand's up. You're going to ding me for something. What did I do? What did I do?
Well, since that's such a temporary law, shouldn't it be a resolution instead of an ordinance?
Oh, wow. Oh, wow. Did you hear the comment? Since this law expired at noon next Tuesday, isn't it of a temporary nature? And therefore, shouldn't it have been a resolution instead of an ordinance? Love the creativity. That's brilliant. I like that. I have seen case law, and I got some in the book, like White versus Town of Inglis, where something was passed as a resolution that needed to be an ordinance and therefore was unconstitutional on its face. I have not seen case law to the opposite, where something was passed as an ordinance that needed to be a resolution. Pundits opine that even though it can be a resolution, you could pass it as an ordinance, and that would be sufficient. But these are pundits that are opining. This has not been litigated. I agree with the pundits, but we could all be wrong. So I respect the creativity of that argument. Yeah. All right, any other questions? Okay, how about another hypothetical? Oh, but before I do that, this battle of the brains here, your 51 brains versus mine, and your lead counsel, Alejandro. If you'd like, you can just concede my victory. We can quit here. Never. Okay. All right. So then let's get to the next hypothetical, shall we? Hypothetical number 5. Look alive. It's number 5. All right. Here's the bill that became a law. Here's section 8675309. Be it enacted by the Florida legislature that section 8675309 is hereby amended as follows. Number 1 has got a strike through. Okay? And remember, we're pretending that's a title. We're pretending that's a title for our title requirements. So this law will be known as the Florida Right to Work Act. Deleting it. That's what the strike through text means when we're passing a bill into a law. Agreed? Agreed. Number 2, no Florida employer may lay off an employee before giving him 30 days written notice of the layoff. I see no strike through, and I see no additions. How do I know there's no additions? There's no underlined text, right? When we're passing a bill and we're adding language, it has to be underlined, right? Nothing there. Number 3, no Floridian may engage in political lobbying before registering with the Florida Secretary of State. No additions, nothing underlined. No deletions, nothing. Strike through for font. But here's some strike through. Former number 4, strike through. This law expires at noon next Tuesday. That's strike through. All right. And probably in a revisor bill, they'll strike through the number 2 and make it a 1, and strike through the number 3 and make it a 2. But we'll leave revisor bills for later. Lead counsel's got his hand up. Lead counsel is confident. Lead counsel plans to lap me on the track, this race. Yes, lead counsel, what do you, we're thinking out loud, or you got a final answer?
This would be an amending issue.
Okay, we're thinking out loud, and we're seeing an issue with amendments. Well, let me stop you right there. I'm not allowed to amend a Florida law?
Well, you can.
I can. You're right. I can amend a Florida law, but you got to do it in the right way. You see a flaw in the way this was done?
Well, yeah. It's saying it's invalid to reenact the law simply by passing an amendment that does nothing more than state that the soon to expire law expiration clause is strict.
I like it. Yeah. We're assuming it's afternoon next Tuesday, and we're trying to put this law back into place. Lead counsel's saying, strike through the expiration date, or the sunset clause, if you want to use a technically incorrect description by the vernacular, but the law language that gives it its temporary nature or its expiration date. You can't just strike through and thereby keep the law. You're correct about that. Should we stop there? Are there any more violations here? Let's keep thinking out loud. There's 2 hands. We're thinking out loud. I think yours went up first. I'll be right with you. Yes.
So the other violation is that they took away the title without giving it a new title, and every bill or statute has to have a title.
Yeah. When it comes to a name, a law doesn't have to have a name. You don't have to say within Chapter 120 that we'll call this the Administrative Procedures Act. You don't have to say within Florida Statute Chapter 440, we'll call this the Workers' Compensation Law. But you do have to have a title. Yeah, and I was saying that's a name, what you see up there. But later, in a later slide, I'm going to use that as a title. Yep, yeah, okay. So I see what you're saying. I like what you're thinking out loud. I like where you're going with that. Another hand was up over here.
There's also the same single subject issues in previous.
Whoa. Okay. So you see yet again a single subject rule violation. Come on, man. We had 8675309 on the board earlier. It was a single subject rule violation. So the legislature met and they amended the law. I mean, what more do they got to do, right? What more do they have to do? Yeah, actually comply with the single subject rule. Yeah, that's the thing they got to do. Yeah, good for the legislature that they met and they amended this law. That was a clear single subject rule violation. But did this amendment remedy the single subject rule violation? The answer here is no. Is it remedied? No. 2 and 3, subsections 2 and 3 remain. And they're not within the same subject. They're not a corollary of each other. So it doesn't meet that exception. What's the other exception to the single subject rule we should check for? Whether one title ties together 2 seemingly unrelated things. If we pretend for a moment that this name of the law, Florida Right to Work Act, is also the title, if we pretend that for a moment, then getting rid of the title certainly didn't help us qualify for the exception to the single subject rule about add both unrelated subjects to the title, right? I mean, it makes things worse, like you pointed out. It makes things worse, not better. Was your hand up? No. So, lead counsel, on the table here is a single subject rule violation, and we can't enact the law simply by striking the sunset clause. Want to go with both answers, or you want to pick your favorite?
Can I do both?
You sure you got to go with both? Because, man, I'm trying to beat you here, and that's not going to help me. Okay, lead counsel says both. Raise your hand if you want to agree with lead counsel. Or maybe you'd like to override him so I can get some points. The correct answer is what lead counsel says. That's right. We've illustrated here, yet again, the persistence of a single subject rule violation. And that's one arrow in the quiver we should light up. Also, as you correctly pointed out, lead counsel, we have a violation of amending existing laws. So we put the yellow highlight on both those arrows in your quiver. This hypothetical, hopefully, illustrates both flaws. It is invalid to reenact a law simply by passing an amendment that does nothing more than state that the soon-to-expire law's expiration clause is stricken. So, lead counsel, you are absolutely correct. Striking the expiration clause isn't enough to reenact the law. What do you have to do instead, lead counsel? Reprint the law, all of the law that you intend to reenact, and underline it.
Right.
Technically, it's an amendment, it's an addition, because the expiration already happened, right? The other flaw was the single subject rule. And as you pointed out, that flaw persisted despite the amendment of 8675309 Florida statutes. Sometimes a broadly phrased title for the act will justify covering various subjects in that act. A statute will not be unconstitutional for embracing more than one subject if the title is sufficiently broad to connect it with the general subject matter of the enactment. Did we amend the title to meet this standard that you see right here? The answer is no, we did not. Man, we're having so much fun. We shouldn't quit here. And we can't quit here because I'm not winning yet. You get another point. You got 4. I'm still down here -2. I hope I get an opportunity to at least get a goose egg before this is over. Okay. Let's look at hypothetical number 6. Just so I know you're still with me, let me hear a chant. 6, 6, 6, 6, 6, 6, 6, 6. Oh, the enthusiasm. Loving it, loving it. Let's read hypothetical number 6. Let's read it with that William Shatner voice of mine, which is intended as a compliment to Mr. Shatner. Be it enacted by the legislature of the state of Florida that Section 8675309 Florida statutes is hereby amended as follows. Number 1, this law will be known as, there's the strike through, we're striking through Florida Right to Work Act. We're underlining the addition. What's the new language? The Florida Lobby and Layoff Law. Ooh, the Florida Lobby and Layoff Law. Just to make it extra catchy, we're going to call that flaw. Yeah, flaw. Number 2, no Florida employer may lay off an employee before giving him 30 days written notice of the layoff. And apparently, we're going to use sexist language there. Sorry about that. Number 3, no Florida employer may engage in political lobbying before registering with the Florida Secretary of State. So we still got 2 and 3 that seem to be addressing different topics, do they not? Number 4, this law expires at noon next Tuesday. Lead counsel, just quit now or your head. Admit that I win. No? No? Okay, all right. You're batting 1,000, man. You're getting them all right. Can you keep that record going? Tell me what you see here. Before you answer, let's think out loud. Let's all think out loud. What are you thinking? You think it's another amendment issue? Okay. Tell me more.
Well, I think the Florida Constitution here says the law cannot be amended solely by reference. Right?
Okay. All right. Yeah, we gave in Ray D. Woody is our case law example of that. And what we were talking about there with that rule of a law may not be amended solely with reference to its title would mean that instead of using the strike through and the underline, we would state something like Section 8675309 is amended to change this. That's not permissible. That's a violation of that requirement unless you met an exception to that rule. So basically what it's saying is you have to use the format of strike through to show what you're deleting and underline to show what you're adding. And here we've got a strike through, we've got an underline. So as you and I think out loud, maybe that's not going to be our final answer. Maybe. 2 hands went up. Yours was first, I believe.
So I think it comes down to the title.
You think it comes down to the title? You're seeing a problem with the title. Okay.
I don't know specifically if the title would be a problem. But if the title is valid, then I don't think you no longer have the single subject problem.
Yeah, I hear what you're saying, and you're pointing to what we're going to call the title. Technically, this would just be the name of the law, but we don't want to fill up 5 or 6 or 7 lines on this slide with a full title. So we're gonna use the name of the law as the title, and you're playing by that hypothetical rule. Thank you for doing that. And you're saying, well, I've amended the title here, but maybe what are you thinking? What about this title amendment?
Well, so I think you have to find out whether the title has become too broad to be a single bit.
Okay. All right.
If it's not,
So now you're worried about the title being too broad, okay? To answer that question, we're going to turn to the requirements for a title. So the title has to be not inconsistent with the subject of the law, right? And it's got to be fairly related to what the law addresses. So in a worst case scenario, a title could be overbroad. It could be talking about topics which ultimately don't make their way into the law. So you're right, a law can have that flaw, but is this an example of such a flaw? We're changing the title to lobby and layoff law. We're changing it to flaw. So lobby, we see here, no employer may engage in political lobbying for registering with the Florida Secretary of State is number 3. So lobby's in there. And then layoff. And we see in number 2, no Florida employer may lay off an employee before giving him adequate notice. So it is a lobby law and it is a layoff law, is it not? And the standard is so low as to be not inconsistent with what's going on in this law.
right, so to me, it's the chicken or the egg.
Chicken or the egg.
What comes first?
Yeah.
Do you look at the single subject, or does the single subject take a back seat to whatever the title becomes?
And I think it's the latter. And I have nothing but respect for your solid logic here as we think through it. And I point that out because I have to respectfully agree to disagree. I do not believe that this, if we consider this a title, I do not believe this title would be unconstitutionally too broad because of the low standard, not inconsistent with, and the low standard of fairly related to what's in the law. It says it's a lobby law and there's a law about lobbying. It says it's a layoff law and there's a law about layoffs. So I think we're cool.
Because I mean, in that sense, couldn't you write a law about labor and unfair fishing practices? And as long as both are in the title.
So the Labor and Unfair Fishing Practices Act, that'd be the FUFPA. The FUFPA. That's a fun with that.
I'll send it back to the committee to come up with it.
All right, they'll come up with, the committee will come up with the perfect name. Yes.
If you just put title of 2 fairly different items.
Yeah.
Write a law.
Well, now what does that do? If I take a title, right? If I got a bill with 2 unrelated things and I put both those topics in the title, what does that do? Yes.
It makes your title valid, but your law unconstitutional.
It makes your title valid. I agree with the first point. And you said your second point is it makes your law unconstitutional. I'm not sure that I should agree with that second point. Tell me more. Why would taking 2 topics that might be arguably unrelated and making sure both are in the title. Why would that make the title unconstitutional? I don't know that it
The law
would.
itself would be unconstitutional.
Okay, so you're not saying the title's unconstitutional.
The body of the law would be unconstitutional, the title would be okay.
Well, no, what I'm trying to illustrate here is that an exception to the single subject rule is that you take the two seemingly different subjects and you stick them both in the title. And that remedies the single subject rule violation. And why is that an exception to the single subject rule? Because as a bill travels through the legislature, it travels by its title. The title shows up every step of the way. The title's on the agenda. The title is how it's named and called to order and called to a vote. So God forbid, maybe the people voting on the bill didn't take the time to read the entire bill, but they surely heard the title. They surely observed the title. And the title had two topics in there. They may have been unrelated, but they're there. The single subject rule had a purpose. It was attempting to enforce legislative integrity. It was attempting to avoid log rolling. By putting both arguably unrelated things in the title, you avoid the single subject rule violation, and you further the goals of avoiding log rolling and maintaining legislative integrity. Because you know nobody was duped. Nobody was fooled. It wasn't a big highway bill and then stuck in there somewhere was a bonus to a senator that had nothing to do with highways. That wasn't the case because the bonus to the senator had nothing to do with highways was in the title. And everybody heard that and saw that. And when they voted on it, they knew that. So what this illustrates by coming up with this creative title here, maybe lobbying and layoffs have nothing to do with one another, but lobbying and layoffs both have something to do with the lobby and layoff law. By sticking both in the title, I have avoided a single subject rule violation. So that's what we're illustrating here. So I'm going to give full credit to lead counsel because there is no violation. Everything's in the green. Everything's okay. How did we finally get to the point of no violation in this particular hypothetical? We amended it correctly. We used the strike through. We used the underline. There was a single subject rule violation, but it has been remedied by qualifying for the exception of having both arguably unrelated topics clearly stated in the title. And it's okay for a law to expire, even if that's on noon next Tuesday. So everything's in green because there's no violation. None of the arrows in your quiver were successful. This law, as amended, is constitutional, or at least is not unconstitutional on its face under any of these rules. Lead counsel, yes, you've got a question.
Doesn't that destroy the whole reasoning for the single subject rule? Because then you can just have law rolling through the title.
The exception can gobble up the rule, yeah. But remember, we just didn't want to violate the integrity of the legislature. We didn't want anybody defrauded or fooled. We didn't want the log rolling. As the bill passes through the legislature, maybe the public only gets 7 minutes worth of news. Maybe they only read the headlines. But that's all you need is the headline. This title, if you will, is a headline to tell you what it is that they're working on, what it is that they're voting on. Likewise, we hope that the members of the legislature read every word of every page of every part of every bill. But just in case they don't, the topics at least are in the title. So they know what they're voting on, and we as the public know at least the topics of what they're voting on. So yeah, maybe the exception gobbles up the rule. Sometimes. One indicator of a legislature's intent is the title of the law enacting the statute, ordinance, or resolution. The title of an act is not part of the basic act, but has the function of defining the scope of the act. So although the title of the act may not be a part of the statute or ordinance, the title is a valuable aid in determining legislative intent. Hypothetical number 7. Who's still awake? Yeah. All right, number 7. And can't neglect to keep the score. We're 5-0. 5-0. How did I get 2 points? I'm the scorekeeper. Okay. We're 5-0. I just got to get 5 points and then we can all get out of here. No, I won't hold you hostage. Hypothetical number 7. Orange County Ordinance number OC 8675309, which is different than Winter Parks, which is different than Florida legislature. Remember the rules of our hypothetical game here. The prior laws remain on the books and valid. And here's a subsequent law. This is an Orange County ordinance. Be it enacted by Orange County Board of County Commissioners that 1, any employer who gives any employee a 30-day written, it's getting late, isn't it, folks? Any employer who gives any employee a 30-day written notice of a layoff under flaw, which of course was Florida Statutes 8675309, will file a copy with the Orange County Clerk of Court. Number 2, no employer may engage in political lobbying before the Orange County Board of County Commissioners without registering with the Secretary of the Orange County Board of County Commissioners. What flaws have I illustrated here? Don't forget the territorial authority of a municipal sovereign. What if the people of Orange County just honestly don't like the laws of the state of Florida? Can the people of Orange County pass a county ordinance that applies throughout the state of Florida? Can they? I'm hoping to hear you yell, no. No, yes. There's a territorial restriction upon municipal laws. Municipalities have authority to pass ordinances that are applicable within the municipality. Your hand is up.
So the only issue that I could possibly see with this one is that I don't see a title that gives the, no, I see what you're saying.
Yeah. Tell me why. Tell me why it's a problem. We started the conversation. Can Orange County pass a law on the same subject that the Florida legislature passed a law on?
As long as it doesn't overlap, right?
Well, yeah, and that's one way to put it. And I know where you're going. You're saying that the answer is yes, unless there's an unconstitutional inconsistency, such as through preemption, be it express or implied, or through conflict of laws.
Yeah.
Yeah, but generally speaking, yes, both sovereigns can pass laws attempting to address the same problem, attempting to address the same topic. So it's okay that there's a Florida layoff and lobby law in the state of Florida in this hypothetical, and also within Orange County in this hypothetical. But one way to read subsection A, any employer who gives any employee, is that Orange County is attempting to create a statewide database. Can Orange County create a statewide database? No. So that's why I highlight on the big board a violation of proper subject matter. Florida municipal, yes, your hand's up again.
Can it be construed to mean that within its jurisdiction, though?
But if you construe it that way, then that runs by game. Let's instead construe it to mean that Orange County was attempting to create a statewide database. And because it was, the Florida Municipal Home Rule Powers Act grants Florida's municipal legislatures the power to enact any legislation concerning any subject matter on which the Florida legislature may act, except, there are many exceptions, we went over them all, but the one illustrated here is, except an exercise of extraterritorial power, right? So we can't do that. Can't make a law like that. But before we go, was there any problem with number 2? No employer may engage in political lobbying before the Orange County Board of County Commissioners without registering with the Secretary of the Orange County Board of County Commissioners. I think you see a problem. Yes, what problem do you see?
Because even though the employer may be outside of Orange County, they still have to go before the Orange County Board of Commissioners.
Yeah, so I agree with you. I agree that number 2 does not show an extraterritoriality problem or a flaw in the territory, because they're talking about what you're doing within Orange County and before it's Orange County Board of County Commissioners. Correct, I agree. Yes?
But if you have the procedural requirements, because now you're having to change the procedural requirements.
I heard most of what you say. You're saying, is there a procedural requirement because of what? I didn't hear the last part.
Because you have to then.
I shouldn't have interrupted you. I apologize. Yeah.
Because if this implies you have to register with someone else beforehand, right? So now if you're changing it, you have to register with the secretary of one county or a county commissioner, then that would be changing the procedure that requires.
That's true. That is a change in procedure. The procedure under the statewide statute, the Florida statute 8675309, said to register with the Florida Secretary of State. Now, subsequently, this Orange County ordinance is saying that at least when it comes to the Orange County Board of County Commissioners, you're also going to register with the Secretary of the Orange County Board of County Commissioners. So there's a second and supplemental requirement for a lobbyist who's probably already registered with the Florida Secretary of State to now also register with the Orange County Board of County Commissioners. Is that a constitutional flaw in this hypothetical? The answer is no. Why is it not a flaw? Because it's not a conflict of laws. I don't have to violate one of those laws to comply with the other. It's not a violation of the requirement to register with the Florida Secretary of State to also register with the Secretary of the Orange County Board of County Commissioners. I can comply with both laws and I can file both registrations, and my act of complying with each law is not a violation of the other law. Make sense? Okay. Your hands up. Yes.
So, in the real world, hypotheticals.
Saying this ain't the real world? No, these are crazy hypotheticals. You're right.
Would it be construed to mean Orange County citizens, or would that actually be an issue?
I was trying to illustrate Orange County's attempt to create a statewide database. And I respect you if you think my hypothetical could have been phrased a little bit better. In my defense, look how many words I got on one screen, man. And with that said, thank you for attending. Lead counsel knocked it out of the park. Hands out, Alejandro. Thank you, everyone, for attending. May God continue to bless us all. I'll see you next week.